So, what set off this extraordinary judicial convergence? According to court filings reviewed by multiple legal outlets, Trump's attorneys filed nearly identical emergency motions in three separate cases on January 27th, all seeking indefinite postponements based on claims of presidential immunity, ongoing investigations, and scheduling conflicts. Each motion contained nearly word for word arguments that judges had previously rejected. This wasn't about legitimate legal strategy or standard civil litigation tactics. This was about weaponizing the court system to run out the clock. And believe me, when three federal judges issue rulings within hours of each other that use strikingly similar language to reject the same defendant's arguments, you know something enormous has just detonated. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and the federal judiciary have been building for months, fueled by repeated postponement requests, emergency appeals filed minutes before deadlines, and a pattern of what judges have privately described as deliberate procedural abuse. But everything escalated on January 28th, when Judge Tanya Chutkan in the D.C. federal election case issued a 47-page order that legal analysts immediately recognized as far more than a standard denial. The ruling systematically dismantled every argument Trump's team had made for delay and included language that appeared designed to be cited by other judges facing similar motions. The order, dated January 28th and filed at 4:47 p.m. Eastern, didn't just reject Trump's latest postponement request. It cataloged a 6-month pattern of what Judge Chutkan characterized as deliberate attempts to manipulate the judicial process. Page 23 of the ruling contained a section titled Pattern of Delay and Its Impact on Judicial Resources that legal scholars say is virtually unprecedented in its directness. This wasn't about one emergency motion or one scheduling dispute. It was about a calculated strategy to prevent trials from ever beginning. Smash that like button if this is making sense so far. Here's where it really gets serious. When judges in the Southern District of New York and the 11th Circuit Court of Appeals read Judge Chutkan's order, they recognized immediately that she had created a judicial roadmap for handling Trump's litigation tactics. And let's be honest for a moment. Orders that spread this rapidly through the federal judiciary are extremely rare. They don't happen over garden variety legal disagreements or routine scheduling disputes. They happen when judges collectively decide that a pattern of abuse has crossed a threshold that threatens the integrity of the court system itself. Here's what multiple legal sources say happened next. Within 18 hours of Judge Chutkan's ruling, Judge Lewis Kaplan in the Southern District of New York filed his own order in the E. Jean Carroll damages case. The order, a remarkably brief 9 pages compared to Chutkan's thorough analysis, cited her ruling 5 times and adopted her framework wholesale. Sources familiar with the Southern District Clerk's office told Reuters that Judge Kaplan's chambers had requested an expedited copy of Chutkan's order within an hour of its filing. Meanwhile, a 3-judge panel on the 11th Circuit considering Trump's appeal in the Mar-a-Lago documents case issued an unsigned opinion that quoted entire paragraphs from Chutkan's analysis of delay tactics. By the morning of January 29th, Trump faced 3 separate rulings that collectively eliminated every procedural escape route his legal team had been pursuing. The language in these orders is unusually direct and remarkably coordinated. Judge Chutkan's ruling states that the defendant has demonstrated through repeated filings a deliberate strategy to delay proceedings indefinitely through a combination of meritless emergency motions, last-minute appeals of routine orders, and claims of absolute immunity that have been rejected by every court that has considered them. Judge Kaplan's order goes further, noting that this court has observed a pattern of litigation conduct designed not to vindicate legal rights, but to obstruct the administration of justice. The 11th Circuit panel's language is even more pointed, stating that the pattern of appeals before this court suggests a systematic attempt to weaponize the appellate process. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. According to reporters who cover the federal courthouse in Washington, when Trump's lead attorney John Lauro arrived for a previously scheduled conference with Judge Chutkan on January 30th, he discovered that she had invited judges from 2 other Trump cases to participate remotely. Legal analysts say this kind of interjudicial coordination on a single defendant's cases is virtually unheard of outside of organized crime prosecutions. The conference, which was supposed to address routine scheduling matters, turned into what one attorney present described as a unified judicial front against further delay tactics. Sources who listened to the audio feed say Judge Chutkan opened by stating that this conference has been convened to ensure coordination across multiple cases involving the same defendant who has demonstrated a pattern of conduct that affects the administration of justice in multiple jurisdictions. Judge Kaplan, appearing via secure video, reportedly added that the Southern District has observed identical motions, identical arguments, and identical delays that suggest a coordinated strategy rather than case-specific legal positions. When Lauro attempted to argue that each case presented unique circumstances requiring individual consideration, Judge Chutkan cut him off. According to the official transcript, she stated, "Mr. Lauro, I have reviewed the emergency motions filed in 3 separate cases over the past week. They are not unique. They contain identical language, identical legal theories that have been repeatedly rejected, and identical requests for relief that would have the identical effect of preventing trials from proceeding." That's when it became clear this isn't just another round of standard litigation. The bombshell moment came when Judge Chutkan announced that all 3 courts would be adopting a unified scheduling framework that would prevent further delay tactics. Reporters monitoring the conference call say the courtroom fell into total silence as she explained that trials would proceed on coordinated timelines, that emergency motions would require higher standards of proof, and that any further attempts to delay through procedural mechanisms would be met with sanctions. This move sent shockwaves through the legal community. When federal judges publicly coordinate to contain a single defendant's litigation strategy, it signals one thing: the delay tactics have become so systematic and so abusive that the judiciary itself has decided to act collectively rather than allow the system to be manipulated further. This isn't the first time a defendant has faced coordinated judicial action over litigation abuse. Think back to the 1990s when the Gambino crime family's attorneys attempted to delay RICO prosecutions through a flood of emergency appeals and immunity claims. Judge John Gleeson in the Eastern District of New York convened what became known as the Brooklyn Conference, bringing together judges overseeing related cases to establish unified procedures for handling defense tactics. The coordination worked. Trials proceeded. Defendants were convicted. The Second Circuit upheld the approach, ruling that systematic abuse of court procedures justified systematic judicial response. Then there was the 2008 case of Stanford Financial Group, where Alan Stanford's legal team attempted to delay securities fraud proceedings through a strategy nearly identical to what Trump's attorneys are now employing. Judge David Godbey in the Northern District of Texas initially handled each emergency motion individually, exactly as the defense hoped. But after the 11th such motion in 4 months, he reached out to judges in related civil cases. They coordinated. They adopted unified standards. The delay tactics ended virtually overnight. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump's own history with this exact pattern. During the Trump University litigation in 2016, Judge Gonzalo Curiel faced an identical strategy: emergency motions, immunity claims, scheduling conflicts, appeals of routine orders. After months of delays, Judge Curiel issued an order that systematically rejected every tactic and set a firm trial date. Trump's attorneys immediately filed an emergency appeal. The Ninth Circuit denied it within 48 hours, citing the pattern of delay. The case settled 2 weeks later. Now, however, it's different. This time, judges aren't waiting months to coordinate. They're acting immediately, learning from each other's orders, and creating a unified framework before Trump's team can adjust their strategy. The pattern is clear. When defendants abuse court procedures so systematically that it threatens judicial integrity, even judges who typically guard their independence eventually coordinate to protect the system itself. So what allegedly triggered this unprecedented judicial response? According to legal experts who reviewed the 3 key orders, Trump's attorneys violated fundamental principles of litigation ethics and court procedure. The orders collectively document a pattern of filings that legal scholars say crosses the line from zealous advocacy into obstruction. Professor Lawrence Tribe of Harvard Law School, a constitutional law expert with over 40 years of experience, told CNN that the coordination among these judges reflects a recognition that standard procedures are inadequate when a defendant systematically exploits every available mechanism purely to delay. He emphasized that while defendants have broad rights to challenge proceedings, those rights don't extend to weaponizing the court system itself. Here's the kicker. Judge Chutkan's order includes a detailed appendix listing every emergency motion, appeal, and postponement request filed by Trump's team across all cases since March 2023. The document runs to 37 pages. It shows 127 separate filings, 89 of which courts have characterized as lacking merit, filed too late, or seeking relief previously denied. Legal experts reviewing the appendix say it reads less like a litigation history and more like a prosecution exhibit. This wasn't aggressive defense work or creative legal strategy. It was a documented pattern of systematic abuse designed to prevent cases from ever reaching trial. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone regardless of political affiliation. This isn't just about Donald Trump or these specific cases. If a defendant with sufficient resources can delay proceedings indefinitely through a flood of meritless motions and emergency appeals, the entire premise of equal justice collapses. Once wealthy defendants learn they can simply outspend and outlast the system, there's no turning back from a two-tiered justice system where justice depends on your bank account and willingness to abuse court procedures. This puts Trump's legal team in an extraordinarily difficult position. On one side, they face enormous pressure from their client to continue delay tactics that have successfully prevented trials for months. That means filing more emergency motions, appealing more orders, claiming more scheduling conflicts, and seeking more postponements. On the other side, they now confront 3 federal judges who have made absolutely clear they view further delays as sanctionable conduct. The attorneys must choose between satisfying their clients' demands or avoiding professional sanctions that could end their careers. And here's the tricky part. There's no credible legal defense for the pattern these orders document. Either the 127 filings were meritorious, in which case judges in multiple jurisdictions all misunderstood valid legal arguments, or the filings were part of a delay strategy, which means the attorneys may have violated ethical rules requiring candor to tribunals. The choice is between claiming judicial bias across multiple courts or admitting to conduct that could trigger bar investigations. Legal and political analysts are calling this a fundamental shift in how the judiciary approaches Trump's cases. Barbara McQuaid, former U.S. Attorney for the Eastern District of Michigan and current University of Michigan law professor, told MSNBC that the judicial coordination we're seeing reflects a recognition that traditional case-by-case handling has failed. She explained that when a defendant's litigation strategy depends on judges in different cases not communicating or coordinating, judicial independence actually becomes a vulnerability that can be exploited. A former federal prosecutor who requested anonymity to speak candidly added that these orders could potentially support future sanctions motions or even referrals to state bars for investigation of attorney conduct. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, a George Washington University law professor who has frequently defended Trump's legal positions, acknowledged in a recent column that the pattern of filings documented in these orders is deeply problematic. He emphasized that while aggressive legal tactics are appropriate, there are ethical boundaries that constrain attorney conduct, and some of the filings cited in Judge Chutkan's appendix appear to test those boundaries. So let's break down what this judicial coordination could mean. First, the immediate practical impact is devastating for Trump's delay strategy. The 3 courts have now adopted what Judge Chutkan calls a unified framework for evaluating future motions. This framework requires that any request for postponement, any emergency appeal, any claim of immunity must demonstrate it's not merely repeating arguments previously rejected. It must show changed circumstances, new evidence, or novel legal theories. Boilerplate emergency motions of the kind Trump's team has filed repeatedly will be denied on the papers without hearings. Appeals of routine procedural orders will be expedited to prevent them from delaying proceedings. The machinery that has successfully prevented trials is effectively dismantled. Second, the coordination creates enormous pressure on Trump's attorneys. When 3 federal judges publicly state they view a legal team's conduct as potentially sanctionable, other attorneys take notice. Sources familiar with discussions inside major law firms tell the Washington Post that several attorneys initially interested in joining Trump's legal team have withdrawn after reading the January orders. Nobody wants their name on filings that federal judges are characterizing as abuse of process. This compounds Trump's existing difficulty in attracting top legal talent. Finally, the judicial framework creates a template for handling any future cases involving Trump or defendants who might attempt similar tactics. Judge Chutkan's order has already been cited in 3 other cases involving different defendants whose attorneys attempted delay strategies. Federal judges are using her analysis as a roadmap for identifying and shutting down systematic obstruction. The precedent extends far beyond Trump himself. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal implications, this is really about a fundamental principle of American justice. The court system's integrity depends on all parties engaging in good faith, using procedures to vindicate legal rights rather than to obstruct justice. When a defendant systematically weaponizes every available procedure purely to delay accountability, it threatens the entire framework that makes equal justice possible. If courts can't impose consequences for procedural abuse, the system becomes a playground for those wealthy enough to fund endless delay tactics. This scenario is causing sheer panic within Trump's remaining legal team and political operation. Reports from sources close to the campaign indicate that senior advisors held emergency conference calls to determine how to respond to the coordinated judicial orders. Some argued for a public relations strategy attacking the judges as politically biased and part of a coordinated persecution. Others insisted that further attacks on the judiciary could trigger contempt proceedings or additional sanctions. The team is fracturing over whether to escalate confrontation with the courts or attempt to comply with the new unified framework. Meanwhile, Trump's core supporters are absolutely furious at the judges involved in the coordination. Social media platforms are flooded with calls to impeach the judges, accusations of a judicial conspiracy, and threats of political retaliation if Trump returns to office. To the base, this represents the ultimate proof that even the court system has been weaponized against their candidate. The coordinated rulings are framed not as a response to litigation abuse, but as evidence of a deep state conspiracy spanning multiple courts. Things escalated further when Trump himself responded with a series of posts on Truth Social late on January 30th. He called the judicial coordination a corrupt conspiracy by radical judges trying to interfere with the election. He claimed the 3 judges had been appointed by Democrats, coordinated by Biden's Justice Department, and were part of a broader plot to prevent him from campaigning. The posts named all 3 judges, questioned their integrity, and suggested they should be investigated for election interference. Legal experts immediately noted that attacking sitting federal judges who are presiding over your cases represents exactly the kind of conduct that could trigger additional sanctions. Stay with me. What comes next will completely change how you view the situation. Here's what makes Trump's response even more self-destructive. The 3 judges who coordinated the orders include one appointed by a Republican president. Judge Kaplan, one of the 3, was appointed by Bill Clinton, but Judge Chutkan was appointed by Barack Obama after a career as a public defender, not a prosecutor. The 11th Circuit panel included 2 judges appointed by Republican presidents. Trump's claim of a partisan conspiracy requires believing that judges appointed by both parties with different professional backgrounds and different judicial philosophies all somehow coordinated to target him specifically rather than simply responding to documented litigation abuse. Legal experts immediately flagged the strategic disaster of the response. Neil Katyal, former acting Solicitor General under President Obama and a Supreme Court practitioner, told reporters that attacking judges while you have pending cases before them is perhaps the single worst legal strategy imaginable. He noted that Trump's posts could be introduced as evidence of bad faith in future sanctions hearings, particularly if his legal team files additional emergency motions that judges view as part of the pattern of abuse. This goes far beyond the immediate legal jeopardy Trump faces in these specific cases. It's about whether any defendant, regardless of wealth or political position, can indefinitely delay accountability through systematic abuse of court procedures. If there are no effective consequences for filing 127 motions that courts characterize as meritless or designed purely for delay, it signals that judicial integrity is negotiable for those with sufficient resources. It's not just about Donald Trump or these prosecutions. It's about whether the American legal system has meaningful mechanisms to prevent the wealthy and powerful from simply outlasting justice through procedural warfare. If this blows your mind, hit that like button right now. Here's the situation. 3 federal judges have coordinated to dismantle the delay tactics that have kept Trump out of courtrooms for over a year. They've created a unified framework that makes further obstruction nearly impossible without triggering sanctions. They've documented a pattern of 127 filings that legal experts say may support bar investigations and contempt proceedings. This is no longer just another legal setback or routine appellate defeat. It's a systematic judicial response to systematic litigation abuse. When federal judges, who typically guard their independence, coordinate publicly to contain a single defendant's tactics, we've entered genuinely unprecedented territory. The last time anything comparable occurred involved organized crime prosecutions where the entire criminal enterprise depended on delaying proceedings until witnesses died or evidence degraded. Using those tools against a former president represents a fundamental shift in how the judiciary views his conduct. If there are no consequences for the documented pattern of abuse, it sets a dangerous precedent that any defendant with sufficient resources can prevent trials indefinitely. The machinery Trump's team built to delay accountability could become the template for every wealthy defendant facing serious charges. The question of whether courts can effectively respond determines whether we have equal justice or simply justice for those who can't afford to flood courts with meritless motions. Keep a close eye on this story. Multiple sources indicate that additional Trump attorneys are reviewing whether to remain on his legal teams after reading the coordinated orders and the professional risks they create. Judge Chutkan has scheduled a hearing for February 15th to address implementation of the new unified framework and to consider sanctions for filings she characterized as abusive. The 11th Circuit panel has set oral arguments for February 22nd on whether Trump's pattern of appeals warrants formal findings of bad faith. And judges across multiple cases are watching closely to see whether the coordination successfully contains the delay tactics or whether Trump's team will attempt new strategies to obstruct proceedings. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 3 federal judges just took the extraordinary step of coordinating across multiple cases to dismantle delay tactics they characterized as systematic abuse of judicial procedures. They've created a unified framework that eliminates the tools Trump's team has used to prevent trials for over a year. They've documented a pattern of conduct that legal experts say crosses the line from aggressive advocacy into potential ethical violations. Meanwhile, Trump's response has been to attack the judges publicly, potentially creating additional grounds for sanctions. This isn't just another legal development that will fade from headlines by next week. This is a fundamental shift in how the federal judiciary approaches Trump's litigation strategy, with implications that extend far beyond his cases. What happens next could determine whether courts have effective tools to prevent wealthy defendants from weaponizing procedures to delay justice indefinitely, or whether sufficient resources and willingness to flood courts with filings can successfully outlast any prosecution. The evidence is out there, documented in 3 coordinated judicial orders spanning 93 pages. The framework has been established, creating new barriers to delay tactics. Now we wait to see if Trump's legal team will attempt to comply with the unified standards or continue filing motions that judges have publicly warned could trigger sanctions. The stakes have never been higher, the judicial coordination has never been more explicit, and the test of whether court procedures can contain systematic abuse has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.